so that he can document it as well, and you'll have that evidence if in fact you need it later on also. You need to follow through with whatever your doctor says. That's important because he will help you through. He will be able to document your claim and your injuries all the way through your treatment, and that will be useful at the hearing. If you fail to go to your doctor or listen to his instructions, someone could claim that your injury may have been aggravated because of your non-compliance. So it's very important to go through with what your doctor says, tell him everything you're feeling, and document every time you go so you can use that later on to try to help you recover how you've been damaged. You need to contact your doctor also and have his reports or a slip from your doctor stating that you cannot go to work or why you're missing from work, and report that to your employer also. That'll be useful when he can turn that into his insurance adjuster or the insurance company to try to validate the right to receive workman's compensation benefits. And it's important that if you're going to be off the job for some time or you're going to continue treatment, to make sure your employee knows exactly why so that they can keep a record also. The purpose of all this is to document how your injury is affecting you and your inability to work. Sometime down the road, the employer will contact his insurance company, and they will have an insurance adjuster contact you regarding what occurred, take a statement of the facts, and listen to what evidence you have regarding your disability or your injury. You must cooperate with that employer, and you must tell him what went on, but it's important not to sign any documentation or to waive any and all rights that you might have under the Workmen's Compensation Act. So be cooperative, but don't sign anything until you have the chance to talk to someone who's more experienced in dealing with these matters. The final point is that you should not do anything to finalize any claim until such time as you seek the services of an attorney who's able to practice in that area. If in fact you sign something and you don't exactly know what it means or the ramifications of that signing, then you may only be hurting yourself, because that may be used by someone against you or an adversary to limit your claim or deny your coverage altogether. So I caution you that if you ever have a workman's compensation injury, follow these procedures, but don't do anything significant with anybody from the company until you seek the services of an attorney. I will now defer to my associates to tell you how the Act works and how you're supposed to file a claim.
Under the Kentucky Workers' Compensation Act, persons who are employed by employers in Kentucky have certain rights. These rights are set out by statute, which has been adopted by the Kentucky General Assembly, the body that meets every 2 years to review the state laws. Not all people who work in Kentucky are covered by the Workers' Compensation Act. Some of the examples of people who are not covered by the Act are people who may work part-time, who are on an independent contractor basis, or are working in farm areas, farm labor or agriculture. But generally, most other persons are covered by the Kentucky Workers' Compensation Act. Now, the good thing about the Kentucky Workers' Compensation Act is that it guarantees anyone who is hurt on the job be compensated for their injuries. The employer is not allowed to argue that you should not receive compensation if you contributed or caused your own injury. For example, if you were walking through the plant carrying a box of materials and were not looking where you were going and happened to fall down a flight of steps, the employer would not be able to argue that you should not be able to receive compensation from him because you were not paying attention. This is a difference between personal injury law, when you're injured in a car wreck or injured in an accident outside the job, where the person that you are making a claim against can ask the court to consider if you contributed or caused your own injury. But under Workers' Compensation Act, the employer is not allowed to try to escape from being responsible to you for your injuries, unless the only circumstances in which are exception to the rule, you are horseplaying, engaging in horseplaying, you have been drinking, or you're under the influence of drugs or alcohol at the time of the accident. So with these three major exceptions, any other accident that occurs at your place of business should be compensated under the law. Now, as attorneys, the first question that we always receive is, what am I entitled to under the Workers' Compensation Act? But while the Act is not perfect, because it does not afford employees the rights to all benefits normally available to people under the law, it does set specific benefits that you as an injured employee are entitled to receive. First, the law says that while you are off of your job as a result of your injury, you have the right to receive 66 2/3% of your average weekly income, up to the point of $200 per week. This means the employer has to continue paying this sum while you are off from work, so long as the doctor says that you are unable to work. Secondly, the employer is responsible to pay all of your medical expenses, as well as expenses for what we refer to as rehabilitation. If it is determined that because of your injury you are unable to return to the same job, or you're unable to have the same duties at that job, the employer is responsible to pay those expenses to retrain you for a job that you can work at your place of employment. These rehabilitation expenses might include additional education. They might include some type of strengthening or physical therapy to condition your body to function better. And during this time that you're going through rehabilitation, you also are entitled to receive your compensation for being away from work. Also, your employer is responsible to pay your transportation expenses to and from your doctors or to and from your place of physical therapy, and this should compensate you for having those expenses. If it is determined that you have a permanent injury, that your injury is such that it will not heal or cure itself after your medical treatment, then the law says you are entitled to additional compensation for permanent injury. If you have a permanent injury and are 100% totally disabled, then you are allowed to receive 100% of your temporary total disability benefits throughout the rest of your life. If you are not 100% disabled, then you receive a portion of your temporary total disability benefits for a time period that's set out by the Workers' Compensation Board. Now, this sometimes gets fairly confusing. So if you have a workers' compensation claim, you need to talk to a lawyer about what your rights are and how it is distinguished from a personal injury claim. Unlike personal injury claims, in workers' compensation, an employee does not have the right to seek monies for pain and suffering or for some of the expenses that they have surrounding the injury. So it's very important to discuss this matter with an attorney who might advise you if, in addition to workers' compensation, you had some other rights to receive funds for other people who may have contributed to your injuries. Barry, if I do determine that I have a workers' compensation case and I have found out that I have permanent injury, what steps do I go through in order to file a workers' compensation claim?
Well, the first thing that you need to consider is the time period involved since the date of your injury. This is known in the law as the statute of limitations. This means the time period from the date of the injury until the time you file your claim must be less than 2 years, or it should be 2 years, less than 2 years from the date that the employer ceases making voluntary payments to you on your income benefit. In other words, from the date that you are injured, you can consult an attorney, you can gather your evidence, you can go through a number of steps before filing your claim. But if you don't file your claim within 2 years, you do not have rights under the law against your employer at this point. Your claim would be barred. Now, when you're filing this claim, it will be necessary to complete a number of forms. These documents would be considered a complaint in civil court, but in fact we are before the Workers' Compensation Board. There are a number of documents that will need to be filed, including a form which sets out your complete work history, your complete medical history, the date of injury, some information regarding the employee, his wages, etc. There will also be some medical releases and authorizations that will need to be filed with the court. It is very important in completing these forms to be entirely candid and to give all the information requested. If all the information is not disclosed on the form, and it should come up during the course